Let's continue.
I want to focus first on item number 3, or a valid warrantless arrest. Just some preliminaries about it so that you know what it is about. A warrantless arrest means that there is no need to go to court and ask for an order or a warrant so that the person will be arrested. Remember, as a general rule, the police cannot just arrest someone. The police has to do it with the authority of the court. And that authority is given by virtue of a warrant of arrest. But as an exception, there are situations that justice must be served without delay. So ito yung exceptions na alangan, mag-antay pa tayo. So for the purpose of serving justice, there are situations where the warrant of arrest is not required. This type of situation is called warrantless arrests. But in our discussion, we should call it further as valid warrantless arrests. Kasi importante na dapat the warrantless arrest must be valid. Now, there are two types of warrantless arrests. The first is known as in flagrante delicto, and the other one is called hot pursuit. Bago tayo mag-discuss ng definitions nila, always remember that in both cases, the rules of court requires that the person arrested shall, without delay, be delivered to the nearest police station or jail. Let me explain some concepts here. When you arrest someone, you are removing him of his freedom of movement. That is called detaining a person. You are now limiting his personal right to move. So imagine someone is being arrested. For example, inaresto nyo na yung nagnakaw ng cellphone. So pinosas nyo siya. Sinakay ninyo sa police mobile. Kaya larga na kayo. Tapos, habang nagta-travel kayo, napadaan kayo sa merkado, naamoy nyo yung fried chicken. Ang bango. So kumain muna kayo. Kasama nyo pa yung inaresto nyo. So kain muna kayo. Tapos, larga na kayo ulit. Papuntang police station. Nasiraan kayo ng gulong, na flat. So, nagpaayos muna kayo kasi wala kayong dalang spare tire. Medyo natagalan kayo. Now, to make the situation unimaginable for the sake of our offender, yung isa sa mga kasama nyo, sumakit ang tiyan dahil sa kinain nilang fried chicken. Nag-ikot-ikot muna kayo sa sa poblasyon, naghahanap kayo ng public CR. Medyo tumagal yung kasama nyo. So, imagine how many hours have passed since arresting that person. How long have you deprived that person from food, water, call of nature, or going home to sleep? Under the rules, it is required that you have to deliver the person arrested immediately to the nearest police station or jail. By the way, what's the difference between a jail and a prison? Jail refers to the detention cells, hindi pa convicted. While prison refers to a place of imprisonment as a penalty after the accused has been convicted. Okay, let's continue with the situation. What if the police officers detain the arrested person for too long? Class, the police officers holding the person for too long may become liable for a crime. It is found in Article 125 of the Revised Penal Code, also known as delay in the delivery of detained persons. The felony means delay in the filing of the necessary information, or charging of a person detained in court. You count from the time you have arrested the person, not when he was delivered to the police station. Kasi he was detained from the moment you put on the cuffs on him, yung posas. Remember that in arresting the person, just delivering him to jail doesn't end the process. For someone to be liable under Article 125, it must be failure to deliver that person to the jurisdiction of the court by filing the correct information. So, in between, marami pang pwedeng mangyari the moment you deliver that person to the nearest police station. You will have to travel, di ba, before that. You may have to interview or interrogate him. And that includes having to wait for a lawyer to be present. And you may have to write a report of the crime, the complaint, etc. Now, under Article 125 of the Revised Penal Code, there are a number of allowed hours to detain a person that is provided for by the law. And that depends on the crime which the person is detained for. Because the word deliver means the filing of the correct information with the proper court. All right. What are the R's? 12 hours for crimes punishable by light penalties, 18 hours for crimes punishable by correctional penalties, and 36 hours for crimes punishable by capital punishment or afflictive penalties. Now, in counting the number of hours, night time is not included. Now, let's discuss the definitions of in flagrante delicto and hot pursuit. In flagrante delicto is an arrest when, at the time of the arrest is made, the person arrested has committed, is actually committing, or is attempting to commit a crime in the presence of the person making the arrest. On the other hand, hot pursuit is an arrest made after the crime has just been committed and the person making the arrest has personal knowledge of the facts and circumstances which engenders him a well-founded belief that there is probable cause that the person arrested has committed the offense. The difference is that in flagrante delicto, it is in the presence of the person making the arrest. In flagrante delicto also means caught in the act. So who is caught in the act? The offender. Who caught him in the act? It's the person making the arrest. On the other hand, hot pursuit, ito lang alalahanin nyo. Hindi nakita ng arresting person yung crime. It is not the same as caught in the act. Example, let's talk about the situation of the cell phone snatcher. It is in flagrante delicto or caught in the act when, in the presence of the person making the arrest, three things have happened. The person making the arrest saw the thief take the phone. Second situation, the person making the arrest is looking at the offender taking the cell phone. The third instance is when the arresting officer saw that the offender attempted in taking away the phone. Question, can only the police make an arrest? No. In flagrante delicto, you will notice that the words person making the arrest is used. It does not only say only police officers making the arrest. So, this is where citizens' arrest can take place. So, that means, aside from the law enforcement agents, a person who is just a bystander, a security guard, or a barangay tanod can make an arrest. Now, let's go to a hot pursuit. Hot pursuit is an arrest made after the crime has just been committed and that the person making the arrest has personal knowledge of the facts and circumstances which engenders him a well-founded belief that there is probable cause that the person arrested has committed the offense. Here, the person making an arrest did not see the offender in the act of committing or that he saw that if he has committed or that the offender is about to commit. But he was given information or tip by the victim or witness that a crime has been committed and that it was the person arrested who committed it. Question, who can make the arrest? The same. A person who is just a bystander, a security guard, or a barangay tanod can make an arrest because the term, the person making the arrest is used in the definition. Okay, let's go to the next slide. In our example, let's say the policeman was taking rounds along the streets near our school. Kaya class importante ang police visibility to prevent crimes. Kasi pwedeng magkaroon ng hot pursuit at any given time. And then, a man ran past the police officer. Question, does he know that the man who is running is a thief? No. He does not have personal knowledge that a crime has been committed and that the man who ran past him was a thief. Kasi wala siyang alam pa. No personal knowledge about a crime that took place. What if he arrested him without personal knowledge? Nakita niya lang, tumatakbo, baka masamang tao to. So he arrested. Is that legal? No. That would be an illegal arrest because mere suspicion is not a ground for a warrantless arrest. Now let's say, after that man ran, he heard someone shouting, cellphone ko, ninakaw. And then, that man who is running after the first man was chasing and pointing at the man who just ran past the police officer. Question, does the police officer now have personal knowledge of the crime? Answer, yes. There are now facts and circumstances that he acquired from observing. What are the facts and circumstances? Let's start with the facts. Fact number 1, the victim was shouting, "Ninakaw ang cellphone ko." So the police officer now has knowledge of the crime. Fact number 2, the victim identified the offender by pointing at him while he was running. How about circumstances? These are things that connects the facts that make a person draw a conclusion. In this case, a man running away and a person chasing him means a wrong might have been committed. So the police officer made that connection that indeed, because of the facts and circumstances, a crime might have been committed and that the person running away is probably guilty thereof. So, can there be a hot pursuit? Yes. So class, pay attention to the definition of hot pursuit. Okay, let's review the situations where there is contact with the law. For the purpose of knowing other instances of contact with the law, there are 2 more instances. Number 4 is search warrant, and number 5 is a valid warrantless search. Just like warrantless arrests, I want you to know ahead the situations which calls for a warrantless search, which to be acceptable as evidence must be legally, so they are the following. Number 1, search incidental to a lawful arrest. Number 2, a search of evidence in plain view. Number 3, search of a moving vehicle. Number 4, consented warrantless searches. 5, customs search. 6, stop and frisk. And 7, exigent and emergency circumstances. Now, in all situations, if the search results to possessing of property or effects constituting the crime or subjects of the crime or a means to commit the crime, the appropriate criminal action shall be instituted against the offenders. Pag nagkaroon ng warrantless searches and it is valid, and in the course of the search, meron kayong nakuha na bagay, property, or effects that, number 1, constitutes the crime itself. Meaning, for example, counterfeit money. Mere possession of a counterfeit money is a crime itself. Or number 2, o yung sinabi dito, subjects of a crime. For example, drugs. It is the subject of the violation of the Dangerous Drugs Act. Or a means to commit a crime. For example, murder, possession of a gun that is not registered. So this will be a reason to institute a criminal action.